Hello and welcome back. This is Lecture 5. It is on Chapter 9, Analogical and Legal and Moral Reasoning. This lecture is for weeks 9, 10, and 11. The next lecture, in 2 weeks, covers Chapter 10, with some overlap from previous chapters. This Lecture 5 and my handouts won't be good enough for understanding important material in Chapter 9. You must also consult the text as you work through the exercises and quizzes. See my Chapter 9 summary handout on analogical, legal, and moral reasoning. Also, for sure, watch all of the excellent short videos to which I provide links in Module 3. So in the first section of this chapter, we want to look at arguments based on comparisons. We'll look at their frameworks, how we analyze them, and then how we evaluate them. Again, what's essential in each evaluation of an argument is that we reconstruct it first. And the framework is something like this. Okay, so analogies indicate that there are similarities between two or more things. An analogical argument is going to be an inductive argument. Its conclusion is only probable at best. And they look kind of like this. The first premise says something like things X and Y have certain properties or characteristics in common, A, B, and C, for instance. Premise 2 says X has characteristic K also, and the conclusion says probably Y also has this characteristic K. Here's an example. Persons X and Y have religious convictions about head coverings for women, and X and Y want to spend time in public. Person X, a Catholic nun, deserves to be free from ridicule or persecution. So, probably, person Y, an Islamic woman, also deserves to be free from ridicule or persecution. And when we look at analogical arguments, what we want to notice is that we're comparing two things, in this case, thing S and thing M, or event S and event M, or the wearing of the headscarf in the one person versus the wearing of the head covering in another person. We look where they're in common, where we have this overlap, A, B, C, D, and E, or these properties S and M have in common. Now, the second premise is going to say something further. It's going to say, well, there's this other characteristic. Call it F. And the issue is we are going to infer that since S and M have so much in common, probably S has property F, so too does M. The number one thing to realize about analogies is that they are inductive reasoning. Analogies are not deductive. They rely on comparisons of relevantly similar examples. Arguments are based on analogies when you use similar properties of two or more things as evidence that they also share some other property. The typical pattern goes like this. A and B have properties X, Y, and Z. A has property P, so B probably also has property P also. When analogies are bad or weak, you demonstrate this by pointing out relevant differences. Then any argument, depending on the comparison, is fallacious. We discuss these weak or faulty analogies in Chapter 3. How do analogies work? They use samples, compared cases, to draw inferences between the cases. So we look at samples so that we may say something about targets. In an argument using an analogy, the things, cases, events compared are called the analogs. The primary analog is the sample, which a premise or two describes. And the secondary analog is the target, which the conclusion describes. So analogical arguments are about their conclusions. They're about the targets of the comparison. Unlike analogies, whose target is a specific thing, generalizations, which are also the result of inductive reasoning, generalizations begin with one or more instances and draw a conclusion about all or most members of a group. Analogies and generalizations are different. Analogies compare, generalizations summarize. Here are a couple of examples. Here's an analogy. My dog startles easily and barks when the doorbell rings. And your dog also startles easily. So your dog will bark when the doorbell rings. Generalization. Dogs A, B, C, D, E, F, G, H, I, and J bark when the doorbell rings. So most dogs will bark when the doorbell rings. In each case, we've got a conclusion that isn't necessarily true. However, They're likely true given the assumption. But they function differently in analogies as opposed to generalizations. So analogies are not deductive. In analogies, the target is outside of the sample. Right? You're talking about how your dog barks when the doorbell gets rung. And you want to conclude something about your friend's dog. And so they're outside of the sample. You're sampling your dog. Now, in generalizations, the sample contains the target. You're generalizing from all of your cases to one sort of general summary statement. Analogies are about similar cases. Generalizations are about a set of examples. A couple more examples here before we move on. Here's a sample in analogical argument. Birds capable of flight, again, not all birds are capable of flight, but those that are similar to bats in that both animals are about the same size, and they fly. So probably, wherever birds can fly, bats can fly also. Here's a generalization about bats. This is called enumerative induction. This is basically induction where you generalize based on observations. Every bat we have ever observed has wings, which it uses for flight. So probably all bats have wings that enable them to fly. I mean, we haven't seen all the bats, but all the ones we have seen and observed, all those for which we've collected data, have wings they use for flight. So let's conclude the thing about bats is that their wings enable them to fly. Not necessarily. Certainly some bats, broken wings, don't fly, etc. We need to talk about how to evaluate analogical arguments, and here are 4 of several criteria for evaluating their strength. Again, since they're inductive, they're either strong or weak. It's a continuum. We have to consider the number of things being compared, the variety of things being compared, the number of characteristics claimed to be similar, and the relevance of those characteristics to the conclusion, to what we want to say about the target. Here's an example. My father's Toyota Prius and my mother's Honda Civic Hybrid have the same engine size and are the same color. My father's car averages 48 miles per gallon of gasoline. Therefore, my mother's car will probably average about 48 miles per gallon of gasoline as well. What you have to notice here is that it's not the color that's relevant. Even though they're the same color, that's not relevant to miles per gallon. Here's a sample argument. And again, we always have to reconstruct these so we may more clearly see the relation between the evidence and the conclusion. Dr. Bauer was born in Switzerland and lived there for several years. She is a European Union citizen, and so are her children. Now, I was born in Portugal, lived there for a number of years, and am an EU citizen. So my daughter is probably an EU citizen too. Reconstructing this, premise 1 is X and Y have in common A, born in Europe, B, they live there a number of years, and C, they are both EU citizens. X and Y here being Dr. Bauer and myself. Number 2, X has children that are D, European Union citizens. And so concluding number 3, probably Y, myself, has D also. That is probably my daughter is also an EU citizen. Okay, so let's look at this argument. I think the argument appears strong given the number and relevance of common characteristics compared. Again, the conclusion of analogies is never necessarily true. We must always also consider dissimilarities. So let's look at those 4 comparison questions and the answers to those for this argument. The things compared. The sample is Dr. Bauer and the target is myself, persons X and Y. What are the variations between the compared cases we need to consider? Well, they seem similar mostly, but we don't know if the exact number of years of residency for each in the EU is relevant, for instance. Number 3, what characteristics do they have in common that are relevant to the conclusion? Well, they're both born in Europe, they live there a number of years, they are EU citizens, and they have children, at least one child. Number 4, all listed characteristics appear to be relevant to the conclusion, although there may be significant differences between the sample and the target as yet unrevealed. Let's consider strategies for evaluating these things. So for each analogical argument, we have got to get clear on what kind of argument is going on. So if it's an analogy, some kind of comparison is going on. First, we have to separate arguments that are comparing cases and drawing conclusions from arguments that are generalizing. Both arguments are based on samples, but only one of those arguments says that what's true of the one thing is probably true of the other in virtue of the samples. Okay, that's the first step. Second step is to reconstruct the reasoning, of course. And finally, we want to, and that's analysis, where you reconstruct. Evaluation is when you take a look at whether you think it's a good argument or not. In this case, inductive, strong, or weak. No one objects to a physician using medical books when diagnosing a difficult case. So, we should allow students to use their texts when taking a test, right? Okay, there are overlapping similarities here. On the diagram, we've got S and M being compared. A, B, C, D, and E are the similarities, the properties in common. However, there are also differences, say P, Q, R, and V. And these dissimilarities are significant enough, I think, to defeat the comparison. For instance, physicians need to treat immediate illness and suffering, unlike students who do not. Medicine can involve life or death decisions. Okay, one more example. Is this analogical argument good? Russia and China should stop supporting the current regime in Bolivia. Whenever a CEO fails to run a corporation effectively, the board members are justified in firing that CEO for mismanagement, multiple union strikes, and loss of worker confidence. Bolivia's current lack of government control has led to extreme violence and unrest between competing factions, leading to the murder of thousands of innocent civilians and children. Therefore, Russia and China must follow the rest of the countries in the UN by not supporting Bolivia's government. Okay, in this case, there is a serious disanalogy. The influence that countries have over each other is different from the influence that a corporate board has over a CEO. Employment dissatisfaction and wartime casualties are very different things. There are some unintended consequences we have to consider here. Firing a CEO often requires monetary compensation given to that CEO so that they'll leave. So the current regime might have to be compensated as well, but that rewards bad regimes. We move now to Chapter 9.2 on legal arguments. Here's an example of a legal argument. Medical malpractice occurs when a professional deviates from standards in his or her profession, thereby causing harm to a patient. The surgeon left forceps in the patient, thus the surgeon is guilty of medical malpractice. The conclusion is about a legal issue, that is, whether the person is guilty of malpractice. In this section, we'll talk about deductive and inductive reasoning. Again, conditional statements will be reviewed, necessary and sufficient conditions, disjunction and conjunction, analyzing a complex rule, analogies, and the role of precedent are all big, important concepts here. We'll take them one by one. The logical basis of legal reasoning goes back to Aristotle. The law is reason free from passion. Persons, when perfected, are the best of all animals, but when separated from law and justice, they are the worst of all. Now, both types of reasoning are used in legal reasoning, deductive and inductive. Deductive reasoning, for instance, occurs when we move from general rules to specific cases. For example, the speed limit is 65 miles per hour on any freeway. This implies that your driving 75 miles per hour on the freeway gets you a speeding violation. It's not a matter of safety here. That's going to be a moral issue. It's a matter of whether you are violating the rules. Inductive reasoning occurs, for instance, when you move from specific cases or legal prior opinions to more general rules applied to other cases, similar cases. For instance, in similar cases of dangerous domestic dogs, lions, tigers, or primates, those kept as pets, which cause harm to bodies or properties, the owners of these animals are liable. Thus, any person who owns a dangerous animal that escapes and causes personal injury or property damage is strictly liable for any personal injury or property damage. We need to review the role of conditional statements. Conditionals occur very often in what we call rule-based reasoning within legal and ethical arguments. Rules with the word if, only if, etc. These can be written in logically equivalent ways. I discussed this a bit already from Chapter 1 when we talked about the basics of implication. A judge may admit evidence of a prior conviction in a new case against a defendant if it falls within either of two categories. If evidence of a prior conviction falls within either of two categories, then it may be admitted in a court case. Another way to say this is that if the judge has refused to admit into evidence a piece of evidence, that information can't be considered when deciding a case. In conditional statements, a sufficient condition means that if the antecedent is true, then the consequent will be true as well. And we've talked about conditional statements when I talked about implication if-then statements. The antecedent being true doesn't make the consequent true. It doesn't cause the consequent to be true. Instead, what a hypothetical or conditional is doing is saying that on the condition that the first part is true, so is the second part. And that's just saying that there is this association where there, according to the claim, there is never a case of where the antecedent is true and the consequent is false. And we talked about this. We did examples in discussion. If we can think of a counterexample, a case where the antecedent is true but the consequent is false, then we can demonstrate that the conditional is false. And the same goes for legal and moral and really any kind of reasoning involving conditionals. A sufficient condition is one that is sufficient for a particular outcome. It's not the only way, but it's one way. A necessary condition is essential, mandatory, or required for another thing to happen or to be realized. For instance, you are allowed to vote in the presidential election only if you are at least 18 years old. Okay, so this is saying if you are 18 years old, you're allowed to vote in the presidential election. Let's break it down. It's sufficient to know that you are allowed to vote if you are at least 18 years old. So being 18 years old is sufficient for being able to vote. Okay? It's necessary to be at least 18 years old to be allowed to vote. Disjunctions and conjunctions. A disjunction is an either-or statement. A conjunction is a statement where you say A and B is the case, or A and B and C is the case. A conjunction is where you use the word and to conjoin two claims. The legal use of disjunction uses an either-or test in which at least one component is satisfied. A lawyer is not permitted to get a contingent fee, L, in a child custody case or divorce case. For instance, here's how it looks. If C or D, then L. Either C or D is sufficient for L. These are three different ways to say the same sort of thing. In the second and third case, I'm symbolizing. A rule containing a conjunction specifies necessary conditions that must be met for the rule to apply. Example, in law, fraud is intentional deception to secure unfair or unlawful gain, or to deprive a victim of a legal right, all of which conditions must be met for something to count as a case of fraud. In other words, it's necessary that all conditions are met for the rule to apply, the rule about what constitutes fraud. I don't want to go too deeply into this, but we will here analyze a complex rule and show how logic functions. There are several different ways to say the same thing. We can say them more simply in condensed either conjunctive or disjunctive form. So here's an example. Evidence that a witness has been convicted of a crime shall be admitted, evidence E, if either A1, the crime was punishable by death or imprisonment in excess of 1 year under the law under which she was convicted, and A2, its probative value of admitting this evidence outweighs its prejudicial effect to the accused, or B1, that establishing the elements of the crime required proof, or B2, admission of an act of dishonesty or false statement by the witness regardless of the punishment. Okay, so all of this can be condensed into the following form. This is similar to when you're doing your taxes and you're trying to look at what the rules are, and they give you these either-ors, and you're thinking, how do I parse this? How do I process this? Well, you can turn it into something like this, where you use letters to stand for the clauses. We've done this already in Chapter 1 exercises and in discussions. Simplifying, we can say if either A1 and A2 is the case, or B1 and B2 is the case, then E, right? Then the evidence gets admitted. We could also say A1 and A2 or B1 and B2, right? The conjunction of the two, either the conjunction of the A's or the B's, is enough or sufficient for evidence being admitted. Third way to say it is we can admit the evidence only if either A1 and A2 is the case or B1 and B2 is the case. So this is how logic helps us in legal reasoning. So here's an example. This is an example of an illegal marriage in U.S. code. A person authorized by law to solemnize marriages, who knowingly solemnizes a marriage contrary to the provisions of this chapter, or knowing of any legal impediment to the proposed marriage, or who willfully makes a false certificate of any marriage or pretended marriage, is guilty of a misdemeanor. And what we're saying here is that, you're guilty of a misdemeanor if you solemnize a marriage that is, not legally acceptable in some way. We can simplify this. If either C or I or G or P, then M. This is saying you're guilty of a misdemeanor if any of those conditions are met. Another way to say it is C or I or G or P is sufficient for M. Or any case of C or I or G or P constitutes M. Those are sufficient conditions for M. You don't have to have all those conditions, but one of those. Another example. A child born of a same-sex marriage, call it M, is the legitimate child of both people, L. As a result, it follows that when there is a marriage between same-sex couples, the need for that second parent adoption to, at the very least, confer legal parentage on the non-biological parent is eliminated when the child is born of the marriage. Okay, we can simplify that. If M, then L and E are the case, right? If it's a child born of a same-sex marriage, then it's the legitimate child of both. And the necessity of legal parentage for the non-biological parent is not necessary, is eliminated. We could say M is sufficient for L and D. For any child that is an M, it is both L and D automatically. If M, then both L and D. All right, now let's tie this together. Let's talk about analogies in legal arguments, legal analogies. Legal reasoning relies on reasoning by comparing similar cases and judging them similarly. You'll hear the term precedent. A precedent is a judicial decision that can be applied to later cases. Rule of law, rules of law. These are legal principles that have been applied to historical cases, and we use those in future cases or similar cases. So here's an example. I want to show how different precedents can be applied to the same action. Say pedestrian Judy, B, our plaintiff, is struck by a car while crossing the street. She brings legal action against the driver, the defendant. So here's Judy's action. And the defendant's argument is that she's assuming a risk when she voluntarily crosses the street. Judy's argument, she's the plaintiff, is that, she has to cross the street and she has a sort of reasonable expectation that she's not likely to be struck by a car. After all, pedestrians have a right of way. And this is how precedent works. The role of precedent is this. Arguing that a prior case should be applied to a present case requires pointing out the relevant similarities of the two cases. Now, the legal use of analogical reasoning is subject to all the same constraints as in everyday use. It can be analyzed and evaluated for its strengths and weaknesses using the criteria for judging analogical arguments: number, variety, relevance of similar characteristics, significant disanalogies, etc. Here's an example. If they make abortions illegal, they should make it illegal for men to desert women after getting them pregnant. If women can't back out of pregnancies, men shouldn't be able to either. I'll leave this to you as an exercise. Here are some things to think about. What are the similarities between women deciding whether or not to have abortions and men deciding whether or not to stay with women? Okay. And you have to ask yourself how similar these cases are. For my part, I can imagine this argument has a sort of superficial appeal, but there are way more important things involved in the case of the again, my opinion, in the case of the woman deciding whether or not to have an abortion, whether or not we should permit abortions to be legal, because the woman's life is endangered in any pregnancy, even if they have adequate prenatal care, which lots of women don't. Their future health and fertility is threatened each and every time they're pregnant. Men backing out of relationships is it's important, but it's not life or death. Okay, so you think about this yourself. I think this argument is fairly weak. Of course, it has its appeal. We could think something like men should not be allowed easily to desert women, and think at the same time that we could accept some legal restrictions on abortion, and that would entail permitting abortion sometimes, especially in cases of a woman's health and welfare, etc. Here's an instance of where a precedent is used to argue a case. St. Louis personal injury law firm Mayor Court helps their client win a precedent-setting case in a Missouri Court of Appeals in a wrongful death case. In July of 2008, Anthony Thomas called emergency services complaining of trouble breathing and acute chest pains. An ambulance and 2 publicly employed EMTs were dispatched to Mr. Thomas' home. After spending 15 minutes checking on Mr. Thomas' vital signs, the EMTs diagnosed the symptoms as nothing more than acid reflux. The next day, however, Mr. Thomas died of cardiac arrest. Early in litigation, the trial court granted the EMTs official immunity pursuant to their motion for summary judgment, citing the recent appellate court decision of Richardson's v. City of St. Louis. The prior case explained that judgment made by publicly employed EMTs, as opposed to private duty EMTs, is similar to that used by police officers in emergency situations. The court in Richardson held that publicly employed EMTs deserved immunity for judgment exercised in emergency situations. The family of Mr. Thomas chose to appeal the decision. Due to Marquard's comprehensive and creative handling of the case, the Missouri Court of Appeals reversed the trial court's judgment. They were able to prove that since the situation the EMTs were responding to was not an emergency situation, immunity should apply. In this case, there was a significant difference. An emergency, the court held, consists of rapidly progressing conditions that demand immediate reactions. As a direct result of this judgment, new law regarding immunity in emergency situations involving EMTs will be set into common practice. In this section of Chapter 9, Section 9.3, we discuss moral arguments. Here's an example. If one makes a promise, then one should keep it. George promised to pay back the money he borrowed. Therefore, George should pay back the money he borrowed. Now, here's a more complex moral argument involving comparisons. I'm sure you can see what's going on in this slide, but let's take a look at this. This is the average person looking at the Pentagon losing $6.5 trillion. Not a big deal. Police killing thousands of people, not a big deal. But an athlete who doesn't stand for the national anthem, this incenses people. And so something is out of proportion here. What we have to consider are value judgments and moral principles that we use to guide our behavior in these cases. And we're thinking we ought to judge cases of similar harm or damage or loss of money or life similarly, but people actually don't. So in this section, we'll talk about value judgments, moral theories, a few of them. I'll look at them briefly. Something called the naturalistic fallacy. I'll look at the structure of moral arguments, comparing them to analogical and moral analogies and other moral arguments. And we'll talk about justifying moral principles, where the justifying moral principle justifies accepting a conclusion of an argument about what we should or should not do. A value judgment is a claim that a specific human action or goal has some degree of importance, worth, or desirability. Justifying any should, someone makes requires knowledge of this value. For instance, here's an argument. You can fly from New York to Los Angeles in about 6 hours. It takes about 4 days to drive the same distance. Here's a conclusion. You should fly rather than drive. This one implies that saving time is important, so what you're valuing here is the time spent traveling. Time spent traveling is time you would not be able to spend on other things important to you. Another conclusion you can derive from this argument is something like the following. You should drive rather than fly. Here, what someone's implying is that seeing the country is important, where time is not so much important as experiencing, the countryside as you drive by. Okay, so there are different types of value judgments. Moral value judgments focus on human actions as either good or bad, right or wrong for fellow humans. For instance, we say murder is wrong. Murdering humans is wrong. Or you should always tell the truth. Okay, now again, value judgments can be used as premises in arguments, or they can be conclusions. And we can make arguments for thinking murder is wrong, or arguments for believing that we should always tell the truth. But then again, these principles, after we give the arguments for accepting them, these are also used to ground further, more specific decisions, like whether or not this particular case of what appears to be murder is wrong, etc. There are value judgments based on personal taste. We'll call these subjective versus factual. We'll call those objective. Now, I don't think subjective and objective are, there's not a clear, bright line between them. I tend to think of these as more subjective, the more they're focused on the interests and values and opinions of the one person, as opposed to more objective, where it's more focused on the opinions, values, preferences of several or many or a community of people. The term should is always used as a kind of directive, telling us what to do. It can be either prescriptive or normative, and there's a difference. Here it is. For a term to be prescriptive, it's going to be requiring. It's going to be offering advice or guiding an action. It's prescribing what we should do. The doctor prescribes medication, an antibiotic, to treat a bacterial infection, say. That's a prescription. If you want to get better, you take the antibiotic. A normative claim is one about the standards, what the standards should be for, say, correct moral behavior. A normative claim would be something like, in general, we tell the truth, at least when under oath. So here's an example. Selection of the healthiest embryos for human implantation in the case of reproductive assistive technologies is an acceptable use of reproductive technology. So what is that? That is not even an argument. That's just a claim. And what kind of claim is it? It matters. It's important. It's a moral value claim. It's not a factual claim, because it's saying what's acceptable. And by acceptable, what's acceptable for humans or by humans, or ought to be accepted by humans, or at least for those humans seeking the healthiest embryos. Not a factual claim. Let's talk about moral theories. Moral theories, ethical theories, moral theories, ethical theories, moral, ethical, same thing. They're the same thing. Moral theories focus on the consequences of human actions, the intentions of human agents, the inherent rightness or wrongness of a human action. I'll mention 5 theories, 5 good theories, 5 useful theories, the details of which are really beyond the scope of this course, and so I do recommend an ethics course. If you find these interesting, I recommend an ethics course anyway. Here are 5 theories in brief for introduction only. Do see my handout on this in the module for sample arguments based on moral principles. I'll talk about emotivism, egoism, utilitarianism, deontology, relativism. You probably have heard these terms. Unfortunately, these terms are used in many different ways by many people. So rather than relying on the term itself, I'll say exactly what I mean by using that term. The term is a shorthand. Don't rely on the term. Instead, focus on the concept as I present it as a case of a moral theory. The thing about a moral theory is it enables us to make judgments based on values and facts and rules about specific cases or even general cases. It's how we decide how we should act. That's the function of an ethical or moral theory. Okay, emotivism. It's the idea that moral value judgments are merely expressions of our attitudes or emotions or feelings, and these vary widely. Emotivists reject the idea that moral value judgments are in any way descriptions of objective moral fact. Moral value judgments are no different from other personal value judgments. Murder is wrong is a personal value judgment. You're just saying you don't like murder. We think murder is wrong. We don't like it. It hurts people, and that's all there is to it, right? It triggers this sort of negative emotion. Now, many people think emotivism is not really a good enough moral theory, although it's the sort of theory a lot of people use. Basically, if something feels wrong, it's wrong. People say, I use my gut to decide whether something's wrong. One criticism of emotivism is this, that if it's correct, there is no objective moral aspect to consider, ever, in legal cases and moral disputes involving, say, neglect, responsibility, and blame. That is, you can never say someone is responsible or blameworthy or even praiseworthy for anything, because they're doing it out of concern for their emotions and their feelings. They're not considering the effects on other people, for instance, or the social contract rules, the U.S. Constitution by which we live. Those things are irrelevant. Emotivism is all about judging based on your feelings, period. That's it. Again, emotivism is a nice view about when you want to explain why you judge something right or wrong based on your own feelings. But it isn't much to offer other people in accepting an action as either right or wrong for them or for the group, or for them letting you do it. All right, let's talk about, I think, a better theory, namely consequentialism. There are many versions of this. Probably the one with which you're most familiar is something called utilitarianism, John Stuart Mill's utilitarianism. I've included some short videos on utilitarianisms, very short, in the module. Have a look at those. So consequentialism describes a group of moral theories in which the moral value of any human action or behavior is determined completely by its outcomes, not its intentions or motives. Let me give you a quick example of that. There are, in use among people, academics and regular people, multiple notions of what constitutes racism. Okay, so racism can be intentional or it can be an outcome. So it's sort of an unfair, prejudicial treatment of people, in effect, regardless of what a person's intention is. And also we're going to call a person racist, with good reason. We'll call a person racist if they intend to do harm to someone based on race, where the race of the person affected is not really relevant to the decision. So it's racist if it's intentional, and it's racist if it's, in consequence, negatively affecting them. Okay? So your basic consequentialist thinks you don't need intentions to judge an action as bad, or, for instance, in this case, racist. It's racist regardless of your intentions. You might not have meant it, but it's racist in its effect. And so this is the case of institutionalized or systemic racism, where, for instance, redlining for generations kept people of color and their families from getting loans, and thereby living in neighborhoods with good schools, and thus guaranteeing their lower, more struggling socioeconomic status. So on consequentialism, the end justifies the means. It's the belief that the value of an action or object is determined by looking at the goal or the purpose or the end of the object, its outcome. Any ought or should is conditional. So if we want to increase human happiness, we ought to decrease human suffering. And there are a couple of varieties of consequentialism here I'll mention, because I do think consequentialism is an excellent theory. It's one of the theories I think we should use in judging actions. And again, it judges actions based on outcomes, not intentions. By the way, the reason we're concerned for outcomes and not intentions as consequentialists is, you can have good intentions, but a bad outcome happens. Something was wrong with the procedure. Something needs to happen so that even the good intentions don't lead to bad outcomes. Look, I don't intend to act like a racist, but what I'm doing is having racist effects, right? Okay, so you've got egoism and utilitarianism. On egoism, the basic principle that everyone is that everyone should act in order to maximize their own or their own group's pleasure or happiness. This is like the America First mentality. It reduces the moral value of an act to the outcome of its consequences, to, say, one person or your own group. Abiding by a social contract, such as the US Constitution, is a kind of group egoism. Again, egoism has a negative connotation. When we say a person is egotistical, we say that they're self-centered, sure. But egoism is this more general theory that it's good to be concerned with yourselves and your family and your group and your community first. And that's not a bad idea. However, it's usually done to the exclusion of the concerns of people outside your group. For instance, here's an egoistic principle. All humans may pursue property and happiness as long as it does not deprive others of the same rights. So here's some criticisms. How can we know all the future consequences of our actions? This is a general criticism. How do we define happiness or pleasure for everyone then? It's easy to go around and survey individuals, but how do we know in general whether the outcome of an action is going to make people such as ourselves or people within our group feel good or live happy lives? And finally, how do we measure or quantify amounts or degrees of happiness or pleasure? That's hard to do. Some people get a lot of pleasure from doing terrible things to people. Some people don't get any pleasure from a number of things other people try to do for them. Let's talk next about utilitarianism, another version of consequentialism. This is the idea that all humans ought to act in order to maximize the greatest pleasure or happiness for the greatest number. This is the greatest good for the greatest number philosophy. The driving force of human behavior, then, is the avoidance of pain and the seeking of pleasure. Famous proponent of this is Jeremy Bentham, the philosopher. The moral rightness or wrongness of an action is a function of the amount of pleasure or pain that it produces. You can measure this. It's not perfect, but it's a better way than just intending good and hoping for the best. Or saying, I see a few people benefit, so maybe other people will benefit. We have to actually measure it. This is where we get kind of scientific. And some of the criticisms of utilitarianism are similar to egoism. What pleases the many may displease the few. In this case, this is a recipe for the majority lording it over the majority interests overriding the interests of minorities. That is, the majority of a group gets a greater say, gets total say over those in the group that are less represented. Next up is something called deontology, and I'll call this rule-based reasoning, rule-based ethical reasoning. And there are many varieties of deontology. I'm just going to focus on Immanuel Kant's categorical imperative. Again, look at the very short 3 to 4 minute video I have for you in the module. This is the theory that our duty to others, what we should do for others, is the first and foremost moral consideration of any action. Consequences are not relevant. And in fact, they distract us from what we ought to do. On this view, intentions are really important. Deontology, then, it's a word derived from the study of duties and principles. And these come from the Prussian philosopher Immanuel Kant. He offers his categorical imperative as the main principle we use for coming up with moral rules. To say categorical is to say that they are absolute, universal, everybody has to follow them. Your actions or behavior towards others should always be such that you would want everyone to act in the same manner. When people say should or ought, it's unconditional. There are no exceptions. For instance, if we say we should not lie, and we form the rule, never lie. Well, that's better than a rule which says sometimes lie, because if sometimes lie is the rule we follow, then we disrespect other people. We make it the case that they can never trust us when we have contracts or promises, or basically tell them anything. Without adopting the rule instead that we should never lie, we can never trust anyone. This is not a consequence. This is what's required to make deals, required to live together, to abide by rules. All right, so one criticism of deontology is that performing our duty can have unacceptable consequences. Now, I have to say that duty-based ethics calls this a feature and not a problem. In many cases, performing your duty might have an unacceptable consequence, like you might hurt someone's feelings, or someone may lose money or hear something they don't want to hear. For instance, someone says, "Hey, do I look fat in these clothes?" Right? Well, look. I mean, obviously, they might feel bad. They probably will feel bad if you tell them the truth. But you are not respecting the truth. You are not respecting them as persons. If when they ask you, and why not presume they're asking for the truth? If they ask you and you don't tell them the truth, you are being dishonest. So the consequence is bad for that person, perhaps even the relationship, if you answer truthfully and tell them they don't look good in that outfit, right? But the consequence is not how you judge. What you judge is, hey, this is a person, they're deserving of respect, and I would want anybody to treat any person with such respect where they would be honest with them. And this is important to us because we sneak the phrase "to be honest" in almost everything we say to other people when we're initiating a conversation. We want to start off from, hey, we're being honest here. We're telling you what we really think is true. So we do pay our respects to deontology, although, of course, many of us are consequence driven. And the flaw, of course, with being consequence driven, I'm just going to say, Kant would say, is that often the consequences are unknowable. You're just speculating. You're hoping they turn out good. And very often they turn out bad as well. So you really don't know for sure. Best not to speculate about consequences. Best to follow rules, which anyone would will that we follow if we're adopting rules that everyone should follow for the sake of respect and trust and kindness towards each other. Let's talk a little bit about relativism. This term has much currency in many debates. In fact, I'm afraid the word relativism now is hopelessly vague. But I'll talk about relativism, about morals here. Moral relativism makes, in general, two claims. It's the idea that all moral value judgments are determined by an individual's personal beliefs or by a society's beliefs toward actions or behavior. It's the idea that there are no objective or universal moral value judgments, since people disagree about what is righteous and what is wrong. And this has appeal. All of us in our lives at some point thinks this is just right. We notice people profoundly disagree about what's right and wrong, and about who's praiseworthy and who's blameworthy. And so this motivates us to believe that there are no right and wrong answers with respect to how we should behave. But I think that's a hasty generalization, a mistake we should avoid. On this view, moral judgments are either subjective or, when applied to an individual, or intersubjective when applied to a society or societies. Okay, so the problem with this view, the number one problem as I see it, is that, yeah, there's disagreement, but it's not that big and it's not that deep after all. For instance, everybody agrees murder, theft, rape, abuse of children, or most people agree that those are universally wrong, bad for people to endure, bad for people to permit, and that such people should be punished. I mean, yes, people disagree about whether a specific action is a case of murder or theft or rape. But they don't disagree on whether such actions are wrong or unacceptable or worthy of punishment. And my evidence is we argue about whether something's a case of murder or rape or child abuse, because it does matter to us. We are not relativists about right and wrong, at least with respect to how to treat the children, how to treat innocent individuals, how to treat someone's property. Okay, we might disagree about whether something's a piece of someone's property, but when we do agree, what we agree upon is if it's someone's property, we don't take it because we don't want to take each other's. It's very hard for me to take relativism seriously. It's got fatal flaws such as these. It's not really a theory about how we should behave. It's more a theory about what explains why we think some actions are okay and disagree with other people about what is or is not okay. Again, this is a critical thinking course. I can't go too deeply into this, but I do want to show you how reasoning functions in value judging and concluding about what we should and should not do based on principles and laws and rules and facts and observations, etc. All right, now it's time to talk about something that gets called the naturalistic fallacy. This is a typical misstep in moral reasoning, and I should be fair and tell you that many academics think this is not a fallacy. Um, I think it is, and I'm going to try to tell you why. Right, so there's this principle people use when they reason. It goes something like this: since it's natural for humans to desire pleasure or happiness. I'm going to just run the two together. Of course, classically, happiness and pleasure are not identical, but for utilitarianisms, we treat them the same. Since it's natural for humans to desire pleasure and to avoid pain, all human behavior ought to be directed to these ends. This is a moral principle that utilitarians use. I mean, I don't think it's a bad principle, but the criticism of this is that you really just accept this principle and use it. You can't really justify believing it. You accept it and run with it, fine. You lay your cards on the table and say, this is my assumption. I'm assuming it's better to pursue pleasure and avoid pain. And that should guide our actions, utilitarian says. Okay, but if we want to justify that action, if we want to justify that moral principle, the criticism is that you can't get a claim about what we ought to do from a claim about how things are. It's true that it's natural we desire pleasure, avoid pain, sure. But shall we conclude that we should always operate so as to maximize pleasure and minimize pain? And the issue here, of course, is that, some things we find distasteful, unpleasurable, and yet they have great value for us. For instance, online education. Education in general is not entertainment. It could be entertaining if you had suitably skilled, talented professors. But education is one of those things that's, somewhat painful, especially the testing process. But let's get outside of that for a second. Here's an example of the reasoning error here. I think this is an error. It's a mistake to say that since many people like to gamble, that people then ought to gamble. Isn't it? So that's how the reasoning goes. And I think it's a fair criticism. So if you want to use this moral principle, you have to understand that I just can't imagine. We just don't see any way to justify accepting it based on natural human behavior. Natural human behavior can justify all sorts of bad actions as well. I desire something that's bad for me, or I desire something that doesn't belong to me. And that means I can take it, I can go after it. Nobody really thinks that. So that's why the naturalistic moral principle is not justified on any moral theory, and yet it is a principle which does guide some moral reasoning. I need to take a moment here to talk about the difference between a moral issue and a legal issue. Recall that an issue in an argument is the subject of controversy. And moral issues are different than legal ones in that moral ones pertain to human flourishing, happiness, what's good or bad for fellow humans. And legal issues are concerned with that, and they are often motivated by a concern for moral issues, but legal issues are downstream of moral issues. Legal issues are about what we permit, whereas moral issues are about what's socially acceptable for whatever reasons and values we have. And I'll give you more details of this. I give you lots of examples of this on the handout I have for you in this chapter. Here on the slides, I summarize what's on those handouts. Look at those handouts for more details. I'll go through this fairly briskly. This slideshow is getting too long. Reasoning about legal or moral issues requires that we judge similar cases similarly, or that we treat equals equally, equal cases equally, equal circumstances the same. But whether such arguments are compelling will depend upon how similar cases, compared cases, actually are. Now, legal issues concern what is and is not permitted by convention or society, given preceding decisions and rules, accepted rules guiding conduct. Legal conventions preserve order and social stability. Reasoning about legal issues requires that similar cases be decided the same. And laws are minimal standards of conduct, whereas morals are optimal standards, right? The standards that are good for most of us, most of the time. Laws codify a society's customs, rules, and moral values, but they don't justify them. So in this way, morals and moral concerns precede laws and legal conventions. They motivate them. They are the foundation of legal decisions, but they are not identical with them, and they are more important than them. Moral issues concern what is and is not acceptable behavior, given our values and our principles and our intentions and goals. Basically, anything that affects humans' happiness. Moral rules promote human happiness and preserve human values. That's what they're for. They're supposed to do that. Reasoning about moral issues then requires that similar cases be judged similarly. Being moral implies behaving in a manner consistent with human interests. Moral concerns precede, they motivate, they override legal or professional restrictions because laws and codes protect and serve human interests. First, we have the interests, and then we think about what rules we should make, what rules we should produce that are enforceable to make people comply, respect fellow humans, comply with laws. For instance, there are in history, in American history at least, many cases of legal actions that are immoral, and there are moral actions that are illegal. Okay? Legal is not the same thing as moral because some actions are legal but not moral, and some actions are moral but not legal. And you want to distinguish between legal, permissible by convention, actions from moral, acceptable, and principle actions. For instance, here are some legal but immoral U.S. Supreme Court legal decisions. These are famous. And, as an exercise, everybody should be aware of each of these decisions, by the way. And in fact, you can go to Wikipedia and look these up. In the case of Dred Scott versus Sandford, what was going on here was that no people of African descent, free or slave, were allowed to be citizens of the U.S. The Supreme Court decided in 1857. This meant that they didn't have constitutional rights. Now, this decision, this legal decision, legally binding decision that said anybody of African descent, and I mean even partial African descent, did not enjoy constitutional rights. They were not citizens of the U.S., even though they were born here. They were born into slavery. They are not citizens, cannot be citizens. It's 1857. And that was the rule. But people realized that was unfair and treating a person equals as non-equals, treating a person of color as if they were lesser than white people. And this was overturned in 1868. There have been in history up through the 1960s, there were laws on the books forbidding marriage between blacks and whites. It was unconstitutional. You'd be punished. Up until the 60s, this was not permitted. So it was legal to restrict marriage to same-race couples. It was legal to punish mixed-race couplings or marriages. Okay, so and the point here is I'm trying to show you is that just because something's legal doesn't mean it's right. And by the way, there are also moral actions that aren't legal, and this would be, for instance, in the case of Martin Luther King, where you might think in some situations you do not want to abide by miscegenation laws restricting people of color from the rights that fellow American citizens enjoy. So you might think that a law is unjust, and so the right thing to do would be to protest or to try to change that law, right? So let's look at the structure of moral arguments. It's the same as I've been showing you throughout. The only difference, the big difference, the important difference is that the conclusion is about what we should or should not do. In these arguments, our conclusion is often called a judgment. So when someone says don't judge, they're saying don't draw a conclusion about a case. And yet you can't take that seriously, can you? Because if I'm not supposed to judge, that's a judgment about what's acceptable behavior. So they're judging me by saying I can't judge. Oh yeah. So everybody judges everybody. We have to accept that people judge. And the issue is we should judge based on, reasons, rational reasons, and in this case, moral values and goals. There's at least one premise that describes a situation where a decision to act will be made by somebody. This is going to be a non-moral statement. It's just a description. There's going to be a premise that supplies a moral rule or a principle or a command. For instance, the rule that says, never lie, don't break a promise, never murder, respect equals equally. The conclusion is going to assert that a specific action needs to be performed. Example, abstract argument. To say we could assume that x is y, and anything y is morally wrong, and so x is morally wrong. So something is a case of that. So fraud is a case of lying. Anything that's lying is morally wrong, so fraud is morally wrong. Of course, it's also legal if you can catch the person, if you can demonstrate that they committed it. But this is an argument for believing that fraud is wrong because lying is wrong, you see. The moral premise bridges the gap between is and ought. You always want to present moral arguments in standard form when examining assumptions and conclusions. And here I want you to look at sections 5 to 6 of my handout for chapter 9. Again, this is not an ethics course, but I do want to show you how logical reasoning is useful and I think essential to moral reasoning. The following examples feature principles, which are standards or rules from which other rules and conclusions about issues draw support. And the thing about principles, moral principles, is that they're general, they're conditional, they're authoritative, they're guiding. They connect reasons to conclusions logically. And the function of a principle is to justify accepting a moral conclusion, using an argument. And moral arguments will use these principles to support moral conclusions, though the principles themselves need justifying. And in some cases we just accept the principle, we all agree on the principle, even though it's impossible or we can't successfully demonstrate it, right? The more exceptions to a principle there are, the less support there is in the argument. In short, moral and legal arguments stand or fall based on the strength of their moral principles. Again, some examples of moral principles, these are going to be imperatives or rules. There's hypothetical versus categorical. A hypothetical imperative has the form of an if-then. So here's one. If you seek to treat people fairly, then you treat people equitably, right? This is where we get the idea of treating equals equally. That's a categorical one. It's one that applies to the entire category, all the people. No exceptions. Another principle would be one from John Stuart Mill. It's the restrict liberty only if it prevents harm. And so this is a rule for allowing people as much liberty as does not harm other people. Okay. So we wouldn't restrict people's speech simply because it offends other people, right? People don't have a right not to be offended or a right not to have their feelings hurt. If we harmed them, like, incarcerated them or brutalized them for what they said, that would be a violation. That would be a violation of the treating, of the allowing people a similar liberty in a society that abides by the Constitution. I have lots of examples of moral arguments on the handout. Have a look at that. You'll recognize in each of these my requirement that you reconstruct the reasoning. You've got a premise and another premise maybe, and then a conclusion. Okay? I'll just mention one here. Number 2, I want to give you an example of an argument for believing that murder is never okay. So here's my premise. Protect the lives of innocent people. We all seem to agree to this, right? An innocent, for instance, like a child, or like a person for whom insufficient evidence has been given of a crime. So we protect the lives of innocent people, accept that premise. Second premise, either we never permit murder or we sometimes permit murder. Now, just think about that. That covers all the possibilities. That claim is just plain true. You either never permit murder or you sometimes do. Right? Now, let's just accept that principle. Now, if we permit murder ever, like sometimes, then that's going to jeopardize the lives of some innocent people, period. It always will. There's always going to be an innocent person being convicted wrongfully. There's going to be a person believed to be deserving of some sort of punishment, even killing, even what some people would call murder. And the issue is innocence would suffer. That's a consequence. That's a bad consequence of sometimes permitting murder. Not to mention the issue of people not being clear on when it's murder, right? And murder entails intention and all that. And so I think this is a pretty good argument for believing murder is never morally permissible. In fact, this is a consequentialist argument against allowing murder. Sometimes it's an argument for accepting the rule, living by the rule that we should never permit murder, period. And I've got several other examples. Go ahead and review these. These are straight from the handout I have for you. I really want you to see the relation between the premises which are supposed to be justifying adequately accepting the conclusion. And notice in each of these we're getting a judgment about what's an acceptable guiding principle, or we're getting a judgment about what we should or should not do, right? We should refrain from public sex. We should not execute people. These are the arguments people make. Again, these are not based on my personal opinions. These are, I think, pretty good examples of pretty good arguments. And again, the arguments stand or fall based on whether or not you would accept the assumptions. Here's a pretty long one here. This is probably worthy of a longer discussion. I may use this in one of our discussions. This is an example of a definition and principle-based moral argument for the equal treatment of animals. And the grand conclusion here is that we should not eat animals or use them when we don't need to, unless we are willing to do the same to fellow humans. Sounds crazy, but look at the argument. Evaluate it for yourself. All right, so summing up, a few more slides here. Moral arguments are not deductive, ever. We never say, if someone says you should do this or you should not do this, we don't say that's not necessarily true. That's not fair. Their argument is not that you have to do it. They're suggesting, they're saying on the basis of these reasons. It's inductive at best. Somebody says 90% of Christians believe that stem cell research is morally wrong. And Jerry is a Christian, so Jerry probably believes that stem cell research is wrong. Well, probably he does, because that's the sort of thing that Christians, believe. Many Christians, not all, but many Christians are against stem cell research. They're thinking that the stem cells are, at least technically, potentially future adult humans with rights, etc. Now compare that with the following moral argument. Different kind of argument. 90% of Christians believe that stem cell research is morally wrong. Jerry is a Christian, therefore Jerry ought to believe that stem cell research is wrong. That's a really different conclusion. To say he ought to believe it is to include some assumption about how Jerry ought to believe the way other Christians do. Even that Jerry ought to believe that the arguments against what Christians in general believe ought to believe that those are bad arguments. Jerry ought to believe that stem cell research is never okay, right? So these are different arguments. Analogies also, we've talked about analogies in this chapter. These can also be used in moral arguments to support a moral prescription, a rule about or a statement about what we should or should not do. Now, the premises of an analogical moral argument, an argument based on comparisons, they attempt to link situations that call for a moral decision based on a reasonable, acceptable moral principle. I keep saying this, here's one we all like in some form or other, judging similar cases similarly, right? Of course, the devil is in the details of whether the cases are sufficiently similar. Here's an example. You told me that you think that using marijuana is morally wrong. Not because it's illegal, but because it's addictive and physically harmful after long-term use. But you regularly drink alcohol, even though you are aware of studies that show that it is addictive and physically harmful after long-term use. Therefore, you ought to not drink alcohol because it is morally wrong. Gotta say, this is a pretty powerful argument for marijuana as well as alcohol being morally wrong. I could imagine a person saying, right, this argument's good. We should not drink both because they are unhealthy and addictive, right? Certainly people do, people want to. But the moral argument is pretty strong. Of course, there are weaknesses. You could get to the details of how exactly the alcohol and the marijuana is produced and distributed, and their individual effects on bodies. Still, I have to say, thus far, alcohol production and consumption is well regulated, better regulated. Obviously, some forms are not permitted. The homemade stuff is better regulated so far. That, of course, is changing, perhaps for the good, than, say, cannabis is. And so I think it's a pretty good argument. Again, it stands or falls based on its assumptions, based on how similar the cases are, right? And finally, let's talk about justifying moral principles. Summarize here, that's all. Some moral rules are self-evident, and all that means is that people call them obvious. People more or less agree on them, right? Like don't harm innocent children or feed hungry people if you can. and they are dying or something like that. And so to call something self-evident is a way of saying, can you just accept my assumption in the argument, please, so we can proceed with the conclusion? Self-evident or obvious truths are statements with which any reasonable person would agree. And criticism, of course, is that reasonable people can and often do disagree on moral actions and on what's self-evident. And so you have to have conversations. You have to have agreements. When arguing, you should argue from common ground towards common goals. If people are disagreeing about the assumptions, disagreeing about what's a fact, it's not worth your time. You want to look also for empirical evidence got by controlled, careful, even scientific observations. For instance, evidence that suffering in non-human animals, in animals we eat, for instance, or animals we use for food or research, we want to know that suffering in non-human animals is sufficiently similar to the suffering in humans. Much of the research, in fact, I have to say, all of the research thus far shows that they suffer just as we do. Criticism. Obviously, this appeals to scientific facts and not societal or individual preferences. Some people think that's good. Some people think that's bad. It makes moral value judgments contingent upon biology, right? Upon biological accidents, not human goals. Perhaps it commits the naturalistic fallacy, which I said is not really a big deal, I think. I think it's a mistake to think that just because something is the case naturally, that it ought to be the case. I mean, certainly people are inclined to be selfish and dishonest and acquisitive and desiring of things that don't belong to themselves. It doesn't follow from those natural desires and cravings that we should pursue them, especially when they are harmful to us and those that have the things, or those that would benefit from our not pursuing whatever we want. And finally, we should base more specific rules on more general principles. For instance, when somebody says Black Lives Matter, this pisses a lot of people off. But to say Black Lives Matter, what justifies that is the claim that all lives matter. Now, it isn't a fair response to the claim that Black Lives Matter, that all lives matter, unless the person who says it believes that all lives matter justifies Black Lives Matter. Now, you recall from the logic we discussed in the first chapter that if it's the case that all P's are Q's, then any P then is going to be a Q. That's a necessary conclusion. And so when a person says Black Lives Matter, that's already true if we believe all lives matter. And what you have to ask people who think that they disagree with the claim that Black Lives Matter, or they want to go on about how blue lives or green lives matter, what you have to notice is that either they don't get that Black Lives Matter is an implication of all lives matter, or maybe they don't think all lives matter. And if they point out that blue lives matter, that's right, that's true, all lives matter implies also that blue lives matter. Black Lives Matter and blue lives matter are compatible. There is no conflict there. We don't have to make a choice. So if you don't accept that Black Lives Matter, you don't accept that all lives matter. I can't see, that's logic. Now, the criticism, of course, with basing more specific rules on more general principles is that people don't want to accept the logical implications of moral rules. And in my humble opinion, that's the big debate about whether people accept the claim that Black Lives Matter, who are not apparently sympathetic to the sufferings of people of color. For instance, if you accept that blue lives matter, and you want to make sure people hear that when they also say Black Lives Matter, if you accept that blue lives matter because all lives matter, you must accept that black and brown lives matter as well, which implies that just as we value and protect blue lives, we must also value and protect other lives, black, brown, LGBTQ, etc. I have had no success in pointing out the logic of the claim Black Lives Matter being based upon the universally accepted principle that all lives matter. If you want to have that debate with people, good luck. But that's all I have to say about that. All right, we're finished with this chapter, this slideshow. Here is a list of all the exercises for Chapter 9 that you should definitely do. All of them, do all of them. That's the best preparation for the quizzes. For you guys, it's all about the quizzes and participating in the discussion. I've gone into more gory detail than usual here because I do think moral arguments are really important. I wanted to give you a little bit more than the book gives you. Okay, That's the end of Lecture 5 for Chapter 9.